My name is David Margules, and I'm a partner in the Securities and Enforcement Group here at Ballard Spahr. I have to read that because I've only been at the firm for 6 months, and I often forget where I am. I have that problem sometimes when I wake up in the morning. With me, to my right, your left, is my partner, Norman Goldberger, who is in the Securities and Enforcement Litigation Group. I've known Norman for 20 years. We've worked together on and off at 15 different law firms. We started out together at Claire Harrison, and then when Norman went back to Litvak, I went with him. And then I practiced for 15 years in a small firm. And when I decided to come back to the big firms, Ballard Spahr was really at the head of my list for 2 reasons. One, the reputation and the resources of the firm, and I'll say the reputation was very well earned, appropriate. And the second reason was Norman, that I think Norman is one of the best lawyers with whom I've ever worked, and I've worked with some pretty good lawyers. And so the opportunity after 15 years to come back and be a partner with Norman was something that was too good to pass up. And as a result, I left offers worth $15 million a year, and instead I'm working here for minimum $17 an hour.
I mean, you think I can live up to this hype? You're crazy.
But Norman does let me wash his car periodically. To my left is Jeffrey Litvak. Jeffrey is a senior managing director at FTI Consulting. FTI is one of the national organizations that provides forensic expert assistance, not just in valuation issues, which is Jeffrey's field, but also in substantive areas. We're looking at using FTI, for example, in another case I have, as expert statisticians. So they have a very broad practice and superb professionals. Jeffrey and I have worked together in the past, and I hope to work with Jeffrey again in the future. And in fact, the hypothetical that we're going to be looking at is heavily influenced by one matter where Jeffrey was my expert witness, and another matter where Jeffrey is not at this point the expert. We haven't selected an expert, but Jeffrey has had a lot to do in shaping our understanding of the case. I just did also want to point out, in terms of just quantitative measures, that we've arranged the front table in the form of a bell curve with the amount of hair being the determining factor.
I lost.
No, you didn't.
Oh, yeah, I guess that's right.
Before we get into the program, I want to announce that the next program is going to be on December 10th, also at 8 a.m. here. It'll be on bankruptcy, and Brent Weisenberg from the New York office and Mikhail Bristow from San Diego will be leading that program. And if you have an interest in bankruptcy, it's one worth attending. Today we're looking at the question of business valuation in a litigation context. We're going to talk a little bit about the context, the points in litigation in which valuation tends to come up, and the differences in the way value is approached at these different stages. And then we're going to take a fact pattern which we'll pull apart and look at value-related issues, issues such as the use of experts, the due diligence of experts, the relevance of market information such as stock price, prevailing stock prices, the way markets react to a deal, and how, on the one hand, a group of potential defendants, a board and its advisors, can shape a process that is likely to have a higher probability of avoiding significant legal obstacles by keeping a few things in mind. And for the litigator and for the expert, looking at a process, particularly from the outside, and being able to make some judgments about what buttons to press, what areas to really bear down on. My experience in valuation cases is that parties that go in and build a new valuation case solely for the purposes of litigation that is premised on a fresh look at everything and gives essentially no deference to existing valuation thinking by management is a very, very difficult one to accept, to be given persuasive acceptance by a court. That the more judgment is infused into the process by the expert, the more troubling it is for judges sometimes. And so there's things that are given preferences. There are shortcuts that are taken to some extent. There are instances where quantitative measures are replacing what would otherwise be the use of judgment by a evaluator in a different context. So it's an animal that is somewhat different than what many of us may be used to if we use valuations solely within a business environment.
Yeah, so the other thing I just add is this seminar has as its departure point valuation in the context of either appraisal transactions in stock deals or mergers and acquisitions. The concepts that we're going to talk about, though, can equally be applied to straight-out valuation cases where we're doing lost profits analysis or we're doing how much is this business worth that somebody destroyed. That may be a different kind of way that you run into valuation cases, but the financial concepts are all the same. So the things you'll hear about, income approach, market approach, et cetera, are all concepts that are applicable. What is going to be different here is the amount of deference courts give, I think, to the decisions of management if management does process correctly.
Yep. And the takeaway that we hope for is that if you are on the company side dealing with a valuation project, whether it's the fairness of an acquisition or a divestiture or in any other concept, we hope that you're going to come away from here with enough of an understanding of the process that you'll ask better questions and recognize that the more questions you ask, the more informed you are, the better the process will be, the better the outcome will be. And for the litigators and the deal lawyers, it's recognizing those same kinds of issues assist in presenting the case to the court. If there are valuation questions that seem questionable, they're going to be questionable when the valuation is analyzed by a court. And if you can identify those and figure out alternative ways to get at information, it will help you build or defend the case. So that's our modest effort here. First, I want to just focus for a moment on this issue of valuation and when valuation becomes part of a corporate case. And you can use these concepts, I think, in other settings as well. They may translate better to some than others, but generally in a corporate case, you have a transaction that is presented to a board of directors. The board receives a fairness opinion, not required, but where boards receive a fairness opinion, generally that is viewed by the court as evidence of the board's care and good faith. It's a reasonable and responsible thing to do to hire a valuation professional who tells you that the price that you're talking about is a fair price to the stockholders. So this tends to be at the early stages of the litigation process, perhaps the late stages of the deal development. And at that stage, there's a couple of realities. The first one is that the purpose of the fairness opinion is to support a finding that the board acted reasonably. Because remember, in a merger, the board has to do two things. The board has to vote to approve the transaction, and then the board has to vote to recommend the transaction to the stockholders. And essentially what these fairness opinions say is they support a finding on the board that we think there's a reasonable belief that we have a fair price. As a practical method, in terms of practicality, the expectation is that the folks doing the fairness opinion tend to be moving fairly quickly. They are giving great deference to information that is provided to them by management. Fairness opinions generally list the information that they've been provided by management, frequently say, we rely on these information. And there is a wide variance of due diligence that's provided by the fairness opinion author in terms of how deeply they'll go into what they've received. They generally will test it somewhat, but it's not as extensive as you will see later in the process.
Can I just add one? Just to explain that a little further, the reason it happens so quickly is the fairness opinion can't come to the deal price is struck because you don't know what the price is. It's sort of just logic. But once the deal price is struck, management and the acquirer, generally speaking, wants to get the deal approved as quickly as possible. So the banker or other valuation expert winds up having to do a very quick job. And as David says, they didn't tend to rely on management to a great degree. The other thing I'll say is from time to time, we've been confronted with situations where clients don't want to get fairness opinions. And as David says, they're not required. There's no case that says you must have a fairness opinion or the deal cannot be approved. The problem is that they've become so common and everyone gets one that when you don't have one, it becomes a question. Why don't you have one? And what you'll get when the transaction is challenged, well, did you bother to get a fairness opinion? And if not, and the asking of the question raises the inference that the deal isn't fair. So that's why everybody these days gets fairness opinions. It's one of those things that has just picked up steam and keeps going.
Yeah, it's like taking your shoes off at the airport. I mean, it accomplishes absolutely nothing. But somebody did it once, and so now we're going to be doing this for the rest of our lives.
I mean, in point of fact, I mean, look, you have to look at what really happens. You are paying a banker to give you an opinion that the price is fair. Now, if it's really off-kilter, they won't do it, but they will try. So you have to think about that.
Yeah, and you know, the philosophy to some part was I think the early days was a view that if these are liability transactions in the sense that you know you're going to get sued. You can do it right, you can do it wrong, or you're going to get sued. You're going to pay something, and if it's a bogus claim, you'll pay something. If it's a real claim, you'll pay a lot more. So you might as well do it right and just pay something. But it became part of the part of the defense in a sense became, and you won't see commentators saying this, but the culture really was that the board would lay off part of its liability onto the financial advisors. And that was kind of the theory when these things were really becoming more commonplace in the 80s. But the financial advisors tended to just walk away from the deal. Anybody who's ever tried to litigate one of these things knows that when you depose an investment banker, they only know 3 words of English. I don't remember. And so, you know, they don't view themselves as supporting the deal. They've given this opinion. And they're kind of out of the process. They don't get sued. They don't get tagged for liability. That's changed this year in a very big way. In the rural metro decision, which Norman's going to talk about in a few moments, where in a case where everybody but the investment banker settled out for $10 million, The investment banker who was sued for aiding and abetting breaches of fiduciary duty demanded a trial and got one. And got hit with damages that, with interest, are going to be about $90 million. I think it's 79 plus interest, and it's a couple of years interest, so it's a hefty pot of money.
Which, needless to say, has made investment banks very skittish.
Yeah, but there's some happy lawyers walking around Wilmington.
Oh, there's no doubt about that. And the facts are, you'll hear the facts, but they're pretty out there. But it is interesting, the reaction. You get a bad case, and suddenly the investment banks get much more wary about stuff. Sure.
Do you have any view on the necessity or the rules or general practices around fairness opinions for intercompany transactions or transactions with common ownership amongst separately traded companies?
What do you want me to?
It's a deceptively broad question, but I think the answer is whether you have, it's going to be driven in part by a couple of things. Number one, if they're immaterial transactions, you know, I don't think that those are going to be sources for litigation, and my guess is that the courts would essentially say companies need leeway to operate if you know, unless there's a clear intent towards self-dealing. If it's an immaterial transaction, it's within the bailiwick of the management to manage the company. If you get into more significant transactions or ones where there are self-dealing, the more effective way to deal with it is to have the people who are on both sides of the transaction not have conflicts of interest. And so you know, I'm not sure what kind of transaction that you're looking at, but you wouldn't, for example, have the managers, the cousin of the managers of Staples who works for you order your office supplies. You set up something internal so that on these things of lesser importance, people who aren't connected, who don't have a financial benefit one way or the other, are not the ones who are making those decisions. It's probably the easiest way to do it. And I think most corporations do that pretty naturally.
On the bigger deals, though, I mean, look at the Santa Fe deal, right? I mean, that's the transaction where our friends, the plaintiffs' lawyers, walked away with $300 million. Mm-hmm. And there's a transaction with ownership on both sides, and procedures weren't followed. We'll talk about procedures, but you got ownership on both sides. And I bet there was I can't remember, but I think there was a fairness opinion there, but I don't think it matters. And the fairness opinion is a piece, but not the only piece. But if you're going to do a deal like that, and you have all the other pieces in place, you have independent boards, you have special committees with independent directors, you have all the indicia, the fairness opinion just helps. It becomes like any other transaction. You want to do that. And I think the test is what they would say. The greater the amount of the transaction and the more self-interest there is, or attack of a self-interest, the more you're going to want to have a whole list of protections, including a fairness opinion.
And you said materiality. That's a GAAP standard or an SEC standard. What's the materiality standard, Bill?
I don't think anybody said it. I think it, you know, we all rely on this too much, but a lot of it's Potter Stewart. You know it when you see it. I would probably use an SEC standard. If a reasonable investor would care about it, if you've got two people on the transaction, you don't know that there are two people on the transaction, the fairness opinion is got two people on each side that are the same people, and an investor doesn't really know about that or doesn't have the protections and would care about that, I would start putting in those protections.
I think it's pretty clear that the SEC has ruled that qualitative as well as quantitative aspects of materiality become critical to the investor. And so if it is a concern for the investor, qualitatively, it is material, even though it may not be material from a quantitative point of view.
The Delaware cases use the word important. They always cite to the federal securities laws, but they use the word important. And in the words of Harry Belafonte, it's clear as mud and it covers the ground. The concept is it does not have to rise to the level where it would change an investment decision, but it has to be the kind of information that an investor would consider important to his investment. So it's a very mushy concept. And the reality is that over the last 10 years, the Chancery Court has kind of moved away from pure disclosure law actions. Sometimes they're kind of tails, but people who have claims that are solely disclosure claims, those cases tend to settle at the preliminary injunction stage and don't go much further and get a nominal remedy. It's only if it's in the context of a broader breach of fiduciary duty that has within it disclosure issues that are tied to the breaches of duties that the disclosures themselves get real traction. Other than that, you know, it's certainly a basis. Bad disclosures are a basis to enter an injunction against a stockholder vote. Those things happen, but you then obviously you cure the disclosures and redo the vote. So it's not going to necessarily be fatal to the transaction.
This isn't a legal standard, but I would say one way of trying to approach it, if you're thinking about it, is what's going to attract attention from the plaintiff's bar. Really, a $100,000 transaction probably isn't, because there's not enough fees to be made on it, and no one's going to do anything about that. A $10 million transaction, maybe it is. In between, you got to think about it. But that's not a legal test, but it is a very practical test.
Well, that also could be whatever an investor would consider changing its mind. If it would cause the investor to change its mind, then it's potentially material. And the SEC has been clear that it's both qualitative and quantitative.
Anyway, to go back to this point of the stages where valuation is relevant, at the earliest stage where we're talking about the negotiations and the fairness opinion, we're really talking about valuation, and it's a mushier, broader concept of valuation. Court's not necessarily looking for precision, not necessarily looking for complete accuracy, because the board has to act reasonably and fairly. And the information has to be enough information so that the board has comfort that it is acting reasonably and fairly, which suggests that the valuation at that stage needs also to be reasonable and fair, which is different from saying that it has to be precise, dead on, reliable. It's got to be good enough, basically. The next stage where we see this is plaintiffs will take a hard look at the valuation case that we see that the bankers did, that's described in the proxy statement, and they'll pull all over this to see whether or not there are assumptions underlying that are questionable. At this stage now, this is a more searching analysis, and it's an analysis that is intended to try to poke holes in it to the greatest extent possible. The idea here is to show that the analysis was sufficiently flawed that the board did not meet its due care requirement. Again, it requires really significant frauds because due care is tied to the standard of gross negligence. So you have to have directors who really did not understand what they were told or did not have enough time to evaluate what they were told, or the work that they were given is so sloppy or corrupt, it's just not reliable. An example might be a situation where evaluation is drawn off of a management forecast going 4 years into the future, and for unexplained reasons, the investment bank decides to make significant adjustments to the cash flows 2 or 3 years out, generally reducing them. And we have the case that Jeff and I did recently, we had that. Management had fairly robust projections, and the bankers inexplicitly said, we think that those, yes, they're management's projections, yes, management believes, and we don't believe in them, and they took them down 10% or something like that. Those kinds of things now create questions about the process and questions about the information the board has received. The board is not asking questions about that. It raises issues about the board's due care. But you're starting to deal with valuation in a much more precise setting when you get to this stage of it.
And when we go through the hypothetical, you'll see that this becomes an interactive kind of analysis. What happens is the less the process, the less the fairness, more the scrutiny. So you might be forgiven a mistake in the math. You might be forgiven a mistake in how you apply a particular valuation concept, or there may be argument over a particular valuation concept. If the entire process was fair with independent directors and all the rest, you get some deference to that. If, on the other hand, you don't have any of that, you're going to get no deference, and you can do it the other way around. If the thing is shot full of holes, it begins to look like the process wasn't done very well and people were just trying to get to a price. So it reacts one on the other, and the degree to which you get a precise attack in these merger contexts depends a lot on both process and how bad that the report is. I agree with David that in the merger context, generally speaking, courts are not looking to just do a revaluation. In the appraisal context, which David's going to get to in a minute, but in the appraisal context and in a damage context, or when we're doing damage analysis for lost profits or destruction of businesses, it's a whole different issue. You will see opinions that say, I reject this expert's valuation on this point, I take the other expert's valuation on that point, I rejigger it, I do my own math, or I appoint a court expert and I will appoint something, because the nature of the proceeding is different. The nature of these transactions and merger transactions are not, and merger litigation, is not to fix the price. That's not what people are trying to do. They're trying to see if the deal is fair to the shareholders, viewed at from a kind of procedural fairness analysis. That is, were all the requisites formed, and was it something that the shareholders actually could get a legitimate say on without having a controlling interest dominating? In appraisal or the damage context, what you're trying to do is fix the actual price. That's what you're trying to do. You're trying to come to what is the most accurate possible price that experts can agree upon. So it's just a different animal. Again, the concepts of valuation are the same, but the object of the exercise is different.
I might interject something as it relates to damages, because I teach damages for the American Institute of CPAs. There is a big misnomer or misunderstanding sometimes about lost profits and destruction of business or diminution in value or valuation of a business. A lost profits calculation can either be a temporary interruption of a business or a temporary interruption of a business where it missed its opportunity and there's a loss of going concern value claim as it relates to damages. The company is still in business. It's just in the but-for world, it would have made more money. A destruction of business or a valuation is a present value of its future cash flows, and the company generally in a destruction case is completely out of business. So there is a big difference between lost profits analysis and the actual valuation of the business. And when I go over the process of valuation in Delaware, it is about the valuation of the business. It is not about, generally, it is not about lost profits. At least I've not received any assignment from this firm or other firms as it relates to lost profits within the Delaware courts, but certainly in cases I've testified across the country, lost profits become a prevalent measure of damages. So if there are any further questions about that, I just wanted to clear that up. Does that make sense, Norm?
Yep, I agree.
Okay. I want to just move to the next slide and then come back to this slide to give a little bit of framework to the legal tests that are applied based on the facts where somebody is challenging a transaction. And many of you may know this, and I apologize if you do. But just don't correct my errors, all right? The traditional rule is called the business judgment rule. The business judgment rule basically posits that directors of corporations who act as trustees for the owners of the corporations, shareholders, receive a presumption that their acts are in the best interest of the stockholders. When that presumption attaches, an action can only be defeated if a plaintiff comes forth and essentially shows no reasonable person would have done what the board did. And one can imagine it's a presumption that virtually can never be overcome. My recollection, and I haven't gone back to check this, but I can recall one decision in the Delaware court from about 1987 or 88 where a business judgment rule test was applied and the complaint was not dismissed. And other than that, it's a preclusive presumption. You can't win, and if it's a business judgment test, put your resources into another case. You can essentially switch the burden. If a plaintiff comes forth with enough evidence to create an inference that directors had a duty of loyalty violation, meaning that they benefited in ways, they had economic interests or other interests that put them on the other side of the deal. So if they're heavily invested in the acquirer and will benefit from the acquirer, or if they're officers who have been offered lucrative jobs if the merger is consummated, and there are lots of other interests, but it's factors that, in essence, take away the ability of the director to think about it independently. And there are cases that can be quite creative. For example, if one looks at the old Revlon, the original Revlon decision, Ronald Perlman was making a run at Revlon, and they were trying desperately to sell the company to somebody else, and every time he put more money on the table, they found another bidder that would top it. And the stories at the time were, and I knew people who were on the bidding team for the Perlman side, they were absolutely convinced that the animus towards Perlman was a horror that a Jewish kid from Philadelphia was going to end up owning Revlon Cosmetics. There are other things where you see people that just for animus, for whatever it is, it can be sexist, it can be racist, you know, it can be Hollywood insiders versus Hollywood outsiders. You want to look for all of these kinds of things. It is rare when the interests play out in a way that is not economic, but it does happen. It could be familial relations. You know, my brother's on that board, of course I'm going to do what he wants me to do. But if you can show that a director has a incentive or a bias that pushes him or her to approve a deal that is different from the interests of the stockholders, it's not based solely on is this a good deal for the stockholders, then you may have demonstrated enough to require that the business judgment rule evaporate. The other thing that you can show is that there was not due care. The board was grossly negligent. It did not take into consideration information that was readily available to it. such as asking management what their plans were, such as canvassing the market to see if there were bidders that might be willing to bid more money, such as relying on a investment banking firm that gave a facially laughable analysis. You know, all of those kinds of things feed in. Once
or lack of time.
Right.
Lack of time is something that you have to pay attention to. If you do a deal in 30 minutes, the chances are that somebody's going to say that due care was taken is not chances are not high, because the theory is, again, that the directors are exercising their duties in a way so as to protect their charge, the care of the corporation and the shareholders, and they can't do that if they don't have information and have time to study it.
Yeah, I had a case where we successfully got a preliminary injunction, and the facts were that the company was going to do a transaction with a controlling insider. Everybody knew that there were discussions and had some general sense of what was being discussed. And on a Friday afternoon or Friday evening, they emailed out 200 pages of transaction documents and called a board meeting less than 24 hours later. And, you know, I deposed a director who said that he read the 200 pages on his iPhone. You know, there was another one who said that he downloaded it on his iPad, at which point the judge leaned back and he said, you know, if I download 10 pages on my iPad, it takes like an hour. How long did it take you to download 200 pages? But this was the testimony, and the court was pretty persuaded that they had not spent any time going through these papers, and that they were not going to get a permissive legal standard. Right, so if you've shown these things, you get into what we call entire fairness land. In entire fairness land, initially, the burden shifts from the plaintiff to the defendant, and the defendant now has to prove that the transaction is entirely fair. And there's two aspects of entire fairness. There's fair dealing and fair price. You know, how did you get to the price, and what are the economic benefits from this price? And the court makes it clear that these are to be taken, they're not to be analyzed separately, they're interrelated concepts. If the defendant persuades on entire fairness, and there are plenty of cases where defendants with the burden persuade on entire fairness, you win. And then came a series of cases that had the effect of shifting the burden of entire fairness back to the plaintiff. It's like a ping pong game. If the decision by the board is made by a subgroup of directors where the subgroup is not infected by bias, does not have conflict of interest, maybe some directors do, maybe a majority of the board does, but two don't, we set them up as a special committee. We give them the full power to deal with this deal, and they make a decision. That helps to insulate the process from the notion that the same people are on the side of the deal, if it's a fully functioning special committee. They then take the role of analyzing the deal, of negotiating with the deal, and approving the deal. Where that's done, the burden of entire fairness remains the burden, but now it's the plaintiff that has to prove it's entirely unfair, as opposed to the defendants proving it's entirely fair. There's a second device, which is what they call a majority of the minority vote. If the measure is submitted to a vote of the stockholders, where only the disinterested stockholders vote, often this happens in a transaction where the company owns a majority of the subsidiary stock. So if there's 40% that's out there that's not subject to the majority, the 40% votes. And the transaction has to be approved by the 40%. That also has the effect of pushing the burden of entire fairness back onto the plaintiffs. So with that kind of flipping back and forth, what you can see that really what's at play here are a lot of questions about director interest, director care, the work that was done by them, and how the process developed through which they ended up selling the company.
And the other thing is, I just want to address one practical point. And those of you on both sides, deal lawyers, litigators, all sides, actually business folks, this is a question that comes up all the time. Why do I have to go do this? It's expensive. We all know how it's going to come out. Everybody's on our side. There's no doubt that we're going to win the vote. Can't we just do this? And the answer is no. It's really very difficult to do this without a proper process. Even in Pennsylvania, where we have a different standard than we have in Delaware, we don't have the Revlon standard, in fact. And in fact, in Pennsylvania, you don't have to maximize price. That's not the standard. That's a corporate law. That's a corporate law innovation drafted by our legislature about 30 years ago to make us a more corporate-friendly state. It hasn't worked, but that's the standard. Even in those situations, if you're going to get the benefit of all these favorable presumptions, you have to walk through the hoops. And though it is expensive and though it is difficult, it is far better to do that as a preemptive measure going in than not to do it and have the whole transaction challenged and blown up when the price might in fact be fair, but because you didn't do all the right steps, what happens is it looks like the price isn't fair, and you've got a judge deciding what's really going on instead of you having that situation. It is a cost to the deal. The way our corporate laws are set up, it's a cost to the deal that you have to go through these steps.
Yeah, and just to echo what Norm is saying, for somebody who's on the deal side of this, doing these things right tend to provide a great insulation in the event of stockholder litigation. I always counsel my clients, you're going to get sued whether you do a deal, if you do a deal. And whether you do it right or whether you do it wrong, you're going to get sued. But the difficulty we will have disposing of that lawsuit and what it'll cost you to make it go away go up considerably if you do it wrong. So let's do it right. And the fact is that doing it right, I think, does have a tremendous benefit for stockholders. That going through these processes force boards to deal with issues that they might not deal with otherwise, force boards to think about things and take responsibilities for things, which I believe, and I'm not aware of any empirical evidence of this, but in my own observation, tends to end up with better results for stockholders.
And I echo that. When boards are forced to go through this process and actually get a hold of fairness opinions and actually look at the terms of transactions, people step up to the plate, even people who it turns out you'd otherwise think were interested, and make better deals for the stockholders in the corporation.
I had a question as to whether you folks feel that there's an inherent, sometimes, conflict between the parties as it relates to the independence of the people who prepare the fairness opinions, and I'd like your comments on that.
Well, there are at least 2 articles that I know of that purport to identify structural bias, and they say you can't trust any board to make a truly independent judgment, and in every case there's a conflict, and people would be better off if they had independent board members, completely independent board members, essentially monitors who would pass on the fairness of a deal in advance. Maybe that's true, that it's inherent in the system, but the courts aren't buying that. The courts have never bought that. Structural bias claims have been brought. They've been rejected, as far as I know, everywhere that they've been brought. These articles have been cited as the evidence. And maybe from a practical point of view, from a point of view of you'd think these boards are all interested, and that's what the common person would think, perhaps, but courts aren't buying it.
Yeah, and I would say one of the concerns I've always had, which you used to see pop up in cases sometimes in dicta, but I think has gone by the wayside. When a company is trying to sell itself, there's a number of benchmarks that a company uses. I think that's true anytime any of us try to sell anything, right? It's what's the blowout price that if I could get that, you know, I'm out of here. What is, I think, a fair but aggressive price that I would absolutely take? You know, what is my bottom line? A penny less, I'm not selling. What is, you know, what I think is realistically possible here? But filtering through all of those decisions is also an assumption about what you can get the buyer to pay. So if you feel the buyer is willing to pay ridiculous amounts of money, all of your points for analyzing the price are going to move up a little bit. And if you think that this is a very tight-fisted buyer who is not going to pay full value, you're going to seriously look at things like, is my tipping point too high? Or is my opening bid too high? So there's a clear interplay between what the buyer is willing to pay. There are cases that, in the context of what means fair value, suggest that fair value should be assessed both against the intrinsic value of the entity, but also against what is the best price this buyer would be willing to buy. And if I get a fair deal that based on the intrinsic fairness looks really good, but I feel that I could have gotten significantly more from this buyer had I pushed, Chancellor Allen wrote opinions saying that maybe that's not a fair deal. I think that analysis has kind of fallen by the wayside, but I think it's intellectually a powerful analysis. You know, the directors who say, yeah, this is good enough, we know that we can get another 10% on top of this, but we're happy where we are, I think they violate duties to stockholders, but we don't really see those cases. But it's, again, it's something to think about. I think in a proper case, we will see that, and it'll be very interesting to see how the Chancery Court deals with it, if the board's obligation is to get the best price for the stockholders.
Probably a good segue into your valuation concepts.
All right, so to go back, all right, so our next slide is very illuminating. Norman's going to talk a little bit about some recent developments in the Delaware Chancery Court that directly or indirectly have an impact on business litigation in the Chancery Court.
Well, we've touched on a lot of it, and I don't want to repeat what we've already said, but I do think it's worth talking about the Rbc case for just a minute. In Ray Rural Metro, I think is the way it goes, but I always think about it as the Rbc case, because it goes really, it shows you what happens to when the process goes awry, as opposed to necessarily the valuation going awry. I'll give you a simplified version of the facts, but in essence, you had a situation in which RBC was on both sides of the transaction. They were advising a committee a special committee as to the value of a deal and the fairness of a deal and what price they should be asking, while at the same time persistently going to the one potential acquirer and trying to finance the same deal. And this got so bad that even after they were told no by the buyer on 2 or 3 occasions, they kept right on going back to make it 4 and 5 and 6 occasions. And there was pretty good evidence, not direct, but pretty inferential, that everything that the seller was thinking was going right back to the potential buyer as an attempt by RBC to persuade the buyer to let it finance the loan. And there was testimony that the profits on the loan would have been 10 or 12 times what they were going to make on financing the transaction, on doing the fairness opinion. So you had people on both sides, on top of which The committee itself had no authority to make the deal, but it did. The chairman of the company got involved directly with the negotiations. And when the chancellor looked at it all, he then took all those facts and said, now let me look at the valuation, and found all kinds of holes in the valuation, surprise, surprise, which he then attributed to the improper influence of RBC, and as David told you earlier, smacked them for $78.9 million plus $11 or $12 million in interest. The lessons from that are really simple, and they kind of summarize all the things that we've talked about. You cannot have folks on both sides of transactions representing buyers and sellers or being interested in a transaction or any of the rest and expect that your valuation opinion is going to hold up. Because what the courts are going to do is it's a proxy. They're simply going to assume that the process affected the valuation, and therefore the valuation must be bad. That isn't what they say out loud. They say, against this background where there was a clear breach of fiduciary duty, let us now examine the valuation. And amazingly, they then find 4 holes in the valuation, improper use of projections, improper discount rates, on and on and on, and there goes the whole thing, and you get hit for $78 million in valuation because you've undervalued the company because of your biases. So that's really the point. What has happened here is that in merger litigation, again, I want to differentiate that from damage and appraisal litigation. In merger litigation, process has become a way of shorthanding whether the valuation process is any good. Where the valuation itself is any good, not the process where the valuation itself is any good. So if what happened going in is bad, it almost follows that the valuation is bad. That's the kind of presumption you get. In theory, I suppose, you could rebut that presumption by showing that you really do have a pristine valuation, but because this is not really a precise science and reasonable people can differ about assumptions in valuation, all the benefits of the doubt go against you when the process is bad. And because the benefits of the doubt go against you when the process is bad, out goes your valuation and out goes your deal, and here come damages. So that's the issue on where Delaware law is headed. The rest you've heard already, all the case law and the presumptions and the business judgment rule. So I'll leave it at that, but you'll see when we turn to the hypo that I'll return it again and again to RBC. RBC is an object lesson in what not to do. You can read that case and step by step tick off what you should not do.
Yeah, I would just add that there's one of the ways that I read RBC, and that case was litigated by my former firm before I left. What it stands for more than anything else is that while there are forces in Delaware law that I think are putting a lot of pressure on the shareholder remedy. For example, there are the courts have upheld bylaws that require that shareholder litigation be held in Delaware. And there's a bylaw that was upheld where the company was a North Carolina bank company incorporated in Delaware. And the court upheld the bylaw that said stockholder litigation has to go forward in North Carolina. So this prevents stockholders from filing lawsuits all over the world and shopping for the most favorable judge and using one to sandbag the other, which has been an increasing problem. There's another bylaw that was upheld by the Supreme Court, in which the court held that the bylaws can shift fees onto unsuccessful stockholder plaintiffs. So if you represent somebody who owns 100 shares of IBM and you bring a shareholder claim against IBM and you lose, you and your client are going to be responsible for the way these things are done, $150 million in legal fees. There is a bill that's sitting in the committee in the Delaware legislature that would overturn that authority, but it's unclear whether it's going to be adopted because it's opposed by the Better Business Bureau, Business Roundtable, I guess, actually. So these things are making it less attractive to litigate stockholder claims against Delaware corporations. But when you have this rural metro case, what it does say is, in a proper case, there will be a real remedy. What is fascinating about this case is that prior to the trial, all of the directors settled, and the other investment banker, there were two investment banks, the other one settled. And it was only one investment bank that tried the case. And the court, and they settled for, I think, a total of about $10 million. The court found that RBC, the remaining bank, aided and abetted breaches of fiduciary duty by the board. It then had to find the existence of breaches of fiduciary duty by the fiduciaries. In order for there to be an aiding, there must be a breach in the first instance. And what the court found was that the board had not adequately policed its financial experts because they did not know that the financial experts, RBC, were concealing conflicts of interest. So it's really kind of a circular bootstrap thing here. I as a director, have breached my fiduciary duty because you, as RBC, lied to me and told me that you had no conflicts of interest, and I believed it, and I have no evidence to the contrary. You know, it's a very troubling result, but that's the basis of the opinion, and it does show that where the court felt that there was significant wrongdoing, there were other pieces of as well, but it shows that where the court finds real wrongdoing, it will find a remedy, and will find a punishing remedy. So the trend in Delaware, which looks like it's becoming very favorable towards management, should not be misread as a trend that will tolerate bad behavior.
And I'll reiterate that for Pennsylvania. Again, we have a completely different standard of deference to the decisions of boards on mergers. And in fact, we have the business judgment rule built into it, so long as there are disinterested directors. But, and there's no shifting to this entire fairness doctrine. But I will say that where you get this kind of stuff that happened in the Metro RBC case, with conflicts by the bankers and the fact that the chairman was involved and the fact that the price was telegraphed to the other side, and on and on and on, even a Pennsylvania court is going to find against you. It really highlights the point that process has to be good in order to sustain the valuation. It's not intuitive, it's counterintuitive. You think a valuation would stand on its own 2 feet, but it doesn't.
And that means, frankly, make sure that the professionals that you hire have done it before and know what they're doing.
And ask the conflicts question.
Maybe in writing. All right, we're going to move now to just a point before we turn it over more to the valuation issues. Over the past couple of years, what we've seen is that a lot of cases that 10 years ago were litigated as breach of fiduciary duty cases are now being litigated as appraisal cases. In mergers, subject to certain exceptions, and sometimes by contract in other types of transactions, a dissenting shareholder, a shareholder who voted against the deal, has the right to ask the court to fix the value of his interests and takes that value. So if I own a company where I own stock in a company, the company is subject to a merger and my stock is going to be sold into the merger for $25. If I vote against the transaction or don't vote, I have a right to ask the Chancery Court to place a value on my stock, and I will get that price plus a fair rate of interest in lieu of the merger price. We're going to talk about that in a minute, but this is litigation that had been kind of on the edges, but is growing in frequency over the past couple of years. If you look at it, about 10 years ago, something like 5% of deals where there were appraisal rights ended up with an appraisal petitioner. Last year, it was 17%. Now, I should say there aren't a ton that actually get litigated to the end, but if you look at the results of those that get litigated to the end, it's a pretty good picture for the appraisal petitioner. In the last 4 years, there are 9 decisions that have come down from the Chancery Court on an appraisal. 7 of them were above the deal price. 1 of them was something like 150% above the deal price. 1 was at the deal price. Very, very interesting decision. Basically what happened there was the court found that the management's projections were not reliable, that there were no reliable indications of value, that the only evidence of value that he had was the deal price, and having nothing else, he accepted the deal price as evidence of fair price. And then there was only 1 of the 9 where it came in below the merger price. And since you're getting a favorable rate of interest, which is about 5% per year, if you can get a deal that's slightly below the deal price, and with the play on the interests, you still end up doing okay. And these kind of mechanics do drive more and more business. Now, there's a capping here in the sense that in order to pursue an appraisal case, you got to be prepared to spend a lot of money. You know, it could be $1 million to litigate an appraisal case, including experts. So unless you have a massive amount of stock, because the appraisal petitioner pays the legal fees, so you have to have enough stock with enough upside to make those legal fees work. So smaller companies, it's just not going to happen. Or companies where you don't have a lot of dissident stockholders, it's not going to happen. But you're seeing them in some of the larger ones, such as in Dole. I think there's more than $100 million in stock at the deal price that is being litigated. We have one now where we have about $80 million of stock at the deal price that's being litigated. So you're going to see these larger deals.
And again, to repeat, you're not going to get any of these deference issues. You're going to get a fight among the experts about valuation methods.
Right. The court has to value the company. There's no burdens of proof. The court's going to look at whatever evidence you put in front of them, and the court will make that determination. So and there's no issue of fault here. Sometimes issues of breaches of duty come in because the defendants always come in and say, oh, we had a full and fair process that led to this price. That is presumptive evidence of a fair price. And then that opens the door to attacking the full and fair process. You know, the corruption, the stupidity, just the errors, all of those kinds of things. And but it's not a fiduciary duty case. Okay, we're going to turn now to the overview of valuation, and Jeff's going to pick up on that.
Well, what I'd like to talk about, ladies and gentlemen, is valuation aspects of shareholder litigation and give you kind of an overview of valuation. I'm going to speak to the issues on the slide and kind of dissect them a little bit. But just as an overview, I can tell you that the precision by which we value companies in the Delaware court has increased. And so we take great care in what we do, and it is much related to the case law as well as the uniform standards of professional appraisal practice, which I'm bound by because I'm an accredited senior appraiser with the American Society of Appraisers. So it's really that interplay. So the precision by which we need to operate has increased dramatically, and so you need to be careful if you're testifying in the Delaware courts.
Just to interrupt you. You should not skip over the credentials that he just mentioned, because we've discovered in appraisal valuation that the USPAP standards often, and commentary often provide tremendous grist for the mill when you're taking depositions of the other side's valuation expert. People don't follow the USPAP standards, or they deviate from them without an explanation. And so these organizations, in fact, there exist standards by which these things are supposed to be done. And if you're doing litigation, or if you're on the business side, make yourself familiar with them, because they matter. They have definitions of value, they have definitions of methodologies, they have instructions for how the process is supposed to be done. Deviations from those standards and methodologies will be noted by a court and taken into account.
So in relationship to that, I am bound by the Uniform Standards of Professional Appraisal Practice, and I'm going to translate that into practicality. But also I have to take into account, in working with legal counsel, the court cases, and I'm going to go over those with you kind of in an overview fashion to cover this material. So it's kind of an interplay, and he is right that you should be very familiar, or your expert should be familiar with the Uniform Standards of Professional Appraisal Practice, because after all, I am an accredited senior appraiser with the American Society of Appraisers. So having said that, let's back up and kind of talk about what's involved. A business valuation is a process and a set of procedures used to estimate the value of an owner's interest in a business. And so there are generally accepted valuation methodologies within the financial community, and that's what we're bound by. And there are intricacies to that, of which I will explain. But the discounted future cash flow methodology, in which you're looking at the past financial performance of the entity, and it's an interrelationship between the past financial performance of the entity and its ability to penetrate the market. And so market studies, industry studies, how well they've complied with their projections, et cetera, we test those things and test their margins in order to come up with reasonable projections that will pass muster in the Delaware court. And so discounted cash flow methodology is considered. The market approach, as far as market comparables of public companies, transactions at or near the valuation date of comparable companies, I would tell you that that has come under great scrutiny, and we'll talk about that. And of course, the expert has to usually consider the cost approach, which is usually inapplicable in these sorts of deals, because it is really a balance sheet approach and not really applicable. I would be remiss in not stating the obvious, so let's make sure we're all on the same playing field. Relevant Delaware law is that the court shall determine fair value of the shares exclusive of any element value arising from the accomplishment or expectation of the merger or consolidation together with its interest. So in other words, fair value is really valuing the standalone entity as if the merger did not occur. And that's very important. And so reiterating that, you're under a fair value standard and assuming that the merger did not occur, so you're valuing the deal on a standalone basis. So the next issue that comes about is, well, what do the courts prefer as it relates to the discounted future cash flow methodology, its appropriateness, et cetera? And so let me give you a little sense as to what they say.
Jeff, before you do that, can you just sort of give a two-sentence summary of what you do in a DCF? I'm not sure everybody knows.
Well, what a DCF is really you're taking interim cash flows and you're essentially calculating what the entity's future prospects are for the next 5 years. So let's say the valuation date is the end of 2014. So from 2015 for the next 5 years, in general, to get to stabilized cash flows, you're calculating free cash flow and then ultimately then calculating a terminal value of what the remaining cash flows are worth, or the sales value of the business, the residual value of the business, which is based on usually a Gordon growth model, which grows year 5 and then caps it at a reasonable capitalization rate that is inherent with the risks inherent in the business. So you're doing essentially a projection of 5 years and then capping it and getting a terminal value. Those cash flows, those interim cash flows and the terminal value are then discounted back at what is referred to as the weighted average cost of capital, or the investor's expected rate of return for a particular set of cash flows with those risks, and that's about it.
And you're trying to get to a present value for that, right?
You're clearly discounting back to a present value, but that present value takes into account the inherent risks associated with those cash flows, because in our example, there's a new business versus an established business. And do you value a new business differently than you value an established business? You do, because there are nuances.
It's an important point that I often find difficult with clients and lawyers and experience with this, so I'll just make it again. It isn't simply taking the cash flows plus the terminal values and then coming up with a present value that is some expected rate of return, some interest rate at the bank. It takes into account the risks of the business, because in theory what you're trying to do is figure out, is it going to happen or not, and is it real or not, and what kind of return does the investor expect for his money. You're trying to take all of that into account when you present value it back.
Well, ladies and gentlemen, I testified in a landmark case in Oakland, California, for a new business, and we utilized a 35% discount rate, and the company was in e-commerce and had developed a relationship with Amazon and eBay, but had lost E-Trade's money, about $30 million, and had never made a profit. And then all of a sudden they developed a relationship with Amazon and eBay, and so we then did a 10-year projection and then discounted those cash flows back at a 35% discount rate because of the inherent risks associated with a new business, and given our study of the industry and the use of an industry expert. So Norm is correct. I mean, you have to take into account the uncertainties and the risk associated with those cash flows, which become part of the challenge for the valuation expert. Well, the next issue that, unless there's questions, and please ask your questions at will, there is a deference for the discounted future cash flow methodology. Well, in Hallmark, the discounted flow methodology merits the greatest confidence. In other words, the court has expressed a preference for the discounted future cash flow methodology, provided it's reliable, provided you can make a reliable projection. That becomes an issue of investigation by the valuation professional. And then also what this decision said is, we're not entirely relying on the discounted future cash flow methodology. We're asking the expert to triangulate his findings. So in other words, take into account market comparables if you can find them, and take into account resulting transactions at or near the valuation date. Triangulate in other words, weight those methodologies and come up with a reasonable value.
Another cautionary note. This can vary by jurisdiction. I can tell you in different jurisdictions there are different rules about this, and it can also vary by type of case. This is clearly true in the merger context. But for example, when we were talking about earlier, damages cases and appraisal cases sometimes, in other jurisdictions, you will get no preference for any particular evaluation method, and sometimes in damage cases you'll see expressions of that the best test is the market test and comparables, if you can find near or exact comparables. So you really have to look at each jurisdiction. Although, as I say, in merger cases in Delaware, this is absolutely true. And in real estate cases, as you probably know, comparables are a big part of the valuation process.
Well, incidentally, and I would totally agree, in SATOA, we used a discounted future cash flow methodology because there were no comparables that we thought were appropriate to use. So it was just a discounted future cash flow methodology.
There's different ways, actually, that this analysis of, or the comparison of the different methodologies can be used. There are analysts in some cases, and I know Jeff's done in some cases, where you say, you know, here are my three methodologies, here are the three numbers that they derive. I'm going to give a 10% weighting to this one, a 5% weighting to this one, and an 85% weighting to this one, and then you end up with a blended analysis. More frequently what I see, or I should say as frequently what I see, is a discounted cash flow analysis. The other analyses are used as a gut check. And in fact, we had in EMS, before we got to the formal presentation, we were viewing our analyses as gut checks. We had a discounted cash flow number that came in at a number that all of us thought was pretty high. And Jeff's attitude was, it's really high. It's really high. And he went back and checked all of the inputs repeatedly and was comfortable that the model was a valid model, but it was really high. And the reason he knew it was really high was it was significantly above the deal price, and we had these comps analysis, and it was significantly out of whack with the comps analysis. And so you have a strategic choice there, which is to say, I'm going to go with the one I believe most, which is generally DCF. I've checked it. I think it's valid. There are these other ones that are aberrant. I've used them as a gut check to verify assumptions under the DCF. I can't explain why they're so low. Maybe you can explain. That's, you know, there's a lot of reasons why they might be. But I'm not going to compromise the DCF by adding in somehow different methodologies that come up with dramatically different results. And that's something the court has seen and the court respects from time to time. But the expert in all of these things, where there is judgment involved, the court wants to know why the judgment, what's the basis of the judgment.
And following on that, I have to say, we've had some success, and there's been some success elsewhere, with filing challenges to expert reports that do not take into account sufficient methods of valuation. So, for example, we have been successful in a Daubert challenge in federal court. And those of you who know what that is, it's a challenge to the credentials of the expert for one reason or another, or the report of the expert, better put. But we've had success in saying, look, here's a report that did a market check, but never did a discounted cash flow analysis, and if you can't come to a reasonable conclusion without doing that, and therefore this expert's report shouldn't even be admitted. And I'll tell you, we get two kinds of results on that. Sometimes we win it outright, or sometimes, and more frequently, what you get is, well, I'll let it in for what it's worth, but I got to tell you, counsel, it's not worth much without being a full analysis, and that's as good as a win. So you really have weapons at your disposal if your opposing expert doesn't do it right, and conversely, make sure your expert does it right, because otherwise you're going to be on the other end of that.
Yep. Our immediate past Chancellor Chandler and his predecessor always used to say that there are no rules of evidence in the Delaware Chancery Court, which is largely true. But by the same token, there's a real hostility towards experts that get up and pontificate without explaining what they're doing. So, for example, there is a case where an expert looked at a comparable study analysis where you take certain companies that are viewed to be comparable businesses to the one that you're studying. You look at the ratio between the price at which the stock is trading and some economic measure of the company, usually EBITDA, and then you have a whole list of them with their ratios, and you compare that to your company's ratio. And in the analysis, the court noted that the mean and the median were clustered around 10 times in the set of comparables, but the company's was dramatically different. The company was also in that area. The company was like 11. And the expert eyeballing the data said, we think that even though the mean and the median are around 10, we think that the appropriate multiple is 12. And so since your multiple is only 9 or 10, you fail this test, essentially. And the court said, if these are really comparable companies, a value that is near the mean or the median should be appropriate. And by using a number other than the mean or the median as the number to be compared, that's an admission that these are not comparable companies. And the court threw the entire analysis out. So there are situations where there may be variances from the numbers-driven analysis that may be appropriate, but an expert has to explain why application of the general rule in this instance is not appropriate and would not make sense. Yeah.
How much does the court sort of weigh when you run, in the M&A context, a robust auction versus what a valuation expert would come up with? I mean, because you can do all the calculations of what the valuation would be, but if you went out to 200 people in the market and they're willing to pay what they're willing to pay, it doesn't necessarily matter what you calculate as a valuation, because the cost of the business is what a willing buyer would sell it to a willing seller for. I mean, vice versa.
Yeah, the easy answer to that is that it is one data point that is relevant to the question of value, but it's not dispositive. There is one case where that was found to be dispositive, which I alluded to earlier. The company had no reliable, there just simply were no reliable cash flow projections, so they couldn't do a DCF. There were no comparable companies from which to do a price equity ratio or any other kind of ratios. There were no comparable transactions. So the court found that the only indication that he had of value was a value that was arranged in a arm's length sale of the company, and that was the appraisal value. That's the one where the stockholders got the value from the deal. In general, the courts take it into consideration. It's not considered to be very heavily weighted. There's a number of philosophical reasons for it. One is that giving overwhelming weight to that effectively takes the courts out of the picture, and judges view their role in these settings to determine on some level within some constraints the fairness of a transaction, and a mechanism that effectively eliminates judicial role there is one to be avoided. Secondly, there's a recognition that buyers never have perfect information, and that the buyers and sellers often work under circumstances where there are subtle biases that result in there not being pure arm's length negotiations. And so that becomes difficult. It's not a perfect model of an arm's length sale ever. And then finally, where you have situations where there's going to be significant synergies as a result of the acquisition, the price presumably reflects you know, if you have a company that's intrinsically worth as it is $100 a share, and I have a bidder who's coming in who says, oh, because I can fire a lot of people and save a lot of jobs and combine operations and do all of these other things, our companies together, I can make that stock worth $150 a share, right? So you have $50 worth of synergies, and then the negotiation becomes, how are we going to carve up that $50,000 in synergies, or the $50 in synergies? That's not a perfect process, and particularly in an appraisal, you don't get the synergies if you own the stock. And so the merger price is infected with a number of considerations that really are outside of the appraisal remedy. And so when you put all of those things together, it's an interest, but it's also, there's a lot of suspicions about it, and they haven't, in a organized way, really pulled apart the economics of those kinds of transactions to figure out how to use them as powerful evidence of the pre-merger company's value.
And all that being said, it goes back to the original point. The more process, the fairer the deal looks, the fairer the deal was handled, the more deference you're going to get. That's why you get the business judgment rule, and you have those issues. And when you have that situation where the valuation may vary from the price in some way, and you think there's a reason, your appraiser should have taken that into account. If this has been done right, then the valuation expert, the banker, the appraiser, whoever it is that you've used, should have taken that into account and in reaching the number they put. So that if, for example, the company's standalone basis is worth, you'd think it was worth $100, but because it has significant environmental problems at one of its plants, that should be someplace in the valuation.
I've had numerous litigation cases where synergies have become an issue. And what everybody needs to remember is that synergies are the property of the buyer. And at the date of the acquisition, they're worth nothing unless the buyer is able to exploit the synergies. So while they may be in part of the control premium that the buyer pays to control those future cash flows in the deal, the synergies are really the buyer's property. And if they're not able to develop those great synergies and fire people and make things more efficient, then the synergies may not be worth much at all. And so that just needs to be reiterated, because that becomes a big issue in commercial litigation cases. Now,
there's a question over there now.
Just curious, getting away from really the M&A, but back to the business valuation, litigation. So we sit here in Philly, Pennsylvania. I'm so concerned about Delaware. Right across the river there in New Jersey, we deal pretty extensively between, defining fair value. I mean, you mentioned about the 35% discount here, but when you start talking about in the shareholder...
What's in a new business?
Well, but I mean, just even the concept of discounting that. The big spread he mentioned about, willing buyer, willing seller and all that. You got a pretty big spread between minority discounts and all that. And I'm just curious what you have to say in the business litigation in Pennsylvania, where they're really dealing with what the heck fair value really is.
They say willing buyer, willing seller, right? I mean, that's what you read, and then 100 exceptions, right? I mean, that's the case law in Pennsylvania is not a model of clarity, I have to say. We recently had a case on this issue. It's all over the map. There are discounts for illiquidity. There are discounts for minority shares. There are discounts of all types. There's a reluctance to imply control premiums. But having said that, in almost every area of dispute, there's some common police court case that goes the other way.
I guess my question,
right.
As I said, in New Jersey, at least some of the Supreme Court decisions, they made it pretty clear, right. And they leave you open with extenuating circumstances. Right. But I think I see in Pennsylvania.
It's all over the map. In fact, I'll tell you something that we ran into recently. There's an old Pennsylvania case from the 60s that uses the term investment value. And investment value has a particular meaning under USPAP, as I understand it.
It does.
Let the expert speak to it. But as I understand it, essentially investment value means what's it worth to this particular investor. That's what's come to me in their USPAP. Well, if you read the opinion, it is perfectly clear that what they are talking about is the market approach, because they talk about comparables and they talk about looking at companies that are similar and so forth and so on. And it's clear that that's what they say, but they say the term investment value. So when you go to a court of common pleas and you say somebody uses the investment value term and they cite the Supreme Court case and they use that as their value to pump the price, and you're trying to argue, no, it's not, what you get from a common pleas court judge more often than not is, well, don't argue with me. Supreme Court says investment value is a perfectly appropriate way to evaluate. And when you say to them, well, but it really means market, no, they don't want to hear that.
It's not even so much market, but what do you do as a practical strategy in litigation? Do you have Jeff come in and say, here it is with a minority discount, here it is with this?
I'll tell you what we did, because we actually had it happen, so I can tell you what we did. We took apart that opinion, paragraph by paragraph. The Supreme Court opinion, I can't remember the name of the case right now, but the Supreme Court opinion, we took it apart paragraph by paragraph and matched it to the applicable definition of market value under USPAP and said, look, if you match these, then we put in the investment value under USPAP. And we were able to convince the judge that at least he had a question. He would not throw out the other side's report, but he did say to the other side, look, I got a serious problem with this. I see what you're saying, and yes, the words are the same, but they have a very persuasive case over here, and the case settled as a result. But that's what I think that's what you have to do. You have to take it apart and deconstruct it. And our Supreme Court, Pennsylvania Supreme Court, doesn't take these cases. They just don't get involved in these valuation cases for whatever reason. So the Superior Court hasn't issued very many opinions either on this. There's a host of common pleas court cases, but there's very little guidance from the Pennsylvania Supreme Court.
I think the answer to your question is it becomes jurisdictional, because you have to work with every law firm in each jurisdiction as to what the law is. And so fair value usually means without discounts, but it may mean discounts in Pennsylvania or in New Jersey. So it really depends on the case law. How would you like me to proceed, considering we're at 10 o'clock?
Yes, well, tie it up.
You want me to summarize this portion of it?
Yes.
Or, okay. The courts have a deference to the discounted future cash flow methodology. So that's what we lean on first. And then we try to find market comparables, public companies, in order to derive multiples that will corroborate and can be evaluated to come up with a valuation. And then transactions at or near the valuation date for businesses that essentially do what the subject company does, and sometimes you can't find them. So in kind of summarizing, I will tell you that there is an increased scrutiny on the comparability of guideline public companies. And I have always had a serious concern that unless you have a true set of pure comparables, you're going to have potential problems with the court, because their deference is to defer to the discounted future cash flow methodology. The preference, one thing I would like to mention is it always carries more weight in commercial litigation, whether in any jurisdiction, if you have contemporaneously prepared projections, not for litigation, not for the merger. If you can find those projections, that's going to carry more deference with the court than projections that are prepared for the purposes of litigation. So to the extent that experts love to pontificate their own model, the courts prefer management projections that are prepared contemporaneous, that are not prepared for litigation, and so that became obvious from the case law.
And you want to be a little careful, because projections get performed for a lot of different reasons. So, for example, many companies have sets of projections that are deliberately aggressive because they are management bonus targets. And the expectation is that management is unlikely to hit those results, but if they do, they're going to get a lot of money. That's not the kind of projection that you want. You may also have to kind of piece things together sometimes from sources such as a capital expenditure budget that will tell you that they're planning to change the mode of production. So you want to be very inventive and broad and not necessarily rely solely on what goes up to the board of directors. But the key ones to look for are what go to the lenders and what go out to stockholders, because there's liability to attach if those projections are not fair.
That pitfall is unbelievable. In every valuation case that I've ever had that goes south, it's because there's a set of projections that went to the lenders. And that just gets incredible deference because it's bank fraud to lie to the lenders. And so every court in the world says, well, this is what you send to the lenders, this must be what you really believe. And you get it's all over the map. You get very aggressive ones so they can get loans, and sometimes you get very conservative ones because people are afraid. So
I guess I'll close with, because we're running out of time. The last thing is, where experts have gotten chastised both in the bankruptcy court and in the Delaware courts, and frankly across the country, is not stress testing their projections. And so by the same token, if you're going to be preparing projections, you need to look at how management has done with those projections in the past. Have they made their projections? Have they been way off, 50% off, 20% off, 10% off? And if you can't rely that they have a process where they make those projections, then those projections may not be reliable. How have they shown those projections to board members, and how reliable have those been? To third-party analysts, to bankers, to their auditors. And so, but by the same token, projections are two things. The integration of past financial performance of how the company has done in the past, and then industry studies and the ability to penetrate the market. The interrelationship becomes how the future cash flows are projected. Now, one other thing that was not mentioned by Norm in his rendition, in commercial litigation, in order to get over the standard of reasonable certainty, which is not mentioned in our example, you have to get over the fact that you may have these great projections, but if your balance sheet is broke, then you won't be able, if you can't prove you could have raised the necessary capital to accomplish those projections, then the court is going to probably throw those out. And so in Satoa, we were able to get the E-Trade to come in and testify that they were going to back Satoa and put in $5 to $10 million, and that got us over the hump of reasonable certainty.
Wouldn't the appraisal take into consideration the need for capital and the availability of capital?
That's true, but you have to make a showing in order to get over reasonable certainty to the court that the capital was there, and it can't be a promise. It has to be, I could have raised the money, or the breach included there was a commitment for the money. And if you can't, in commercial litigation, really kind of make a showing to the court that the necessary capital was there to accomplish the projections, then you may have these great projections, but the court is not going to respect that because you're broke or insolvent or highly leveraged, undercapitalized, et cetera. So with that, I'll turn it over to my hosts and for their final comments.
Well, I guess what we're trying to do here again is to really focus folks on some of the complexity that ripples through this area of valuation, how fact-intensive it is, and how significant it is really at all stages of corporate litigation. So for those who are litigators, I think it's important to keep in mind that from the moment you start on a project that has to do with valuation issues with corporate transactions, you need to be thinking about your valuation case and what can be done to make sure that the valuation work is being done in a credible fashion. For the transactional lawyers, you need to make sure that your boards, your decision makers are really getting credible information. Obviously that they are getting good information about any conflicts on the part of the valuation professionals. That clearly has to be a critical factor now. And that the valuation analysis should not just be thrown onto the table by an expert, but should be questioned, examined, pulled apart, looked at again, because the better the analysis is, the better the board's decision is, and the better the board's decision is, the more likely it is that a court will find that there are no claims here and that you get a good result in litigation. For those attacking transactions, it's the other ways around. You know, you want to take a very hard look at the valuation work that's been done at the fairness level, pull it apart, try to understand why things were done in a certain way, look at the company in a lot of different ways, use your valuation experts to help you define discovery, look for the magic bullets, and ultimately make a presentation that you hope demonstrates that the deal price is not fair to the stockholders.
This only tells me we can do another one on practical aspects of trying valuation cases. See you soon.